103, Morton versus the State of New York.
Party to court, please.
Counsel, any rebuttal time?
Yes, Your Honor. I'd like to reserve 5 minutes, if I could, please.
5 minutes. You have it. Go ahead.
Thank you so much. Good afternoon, Your Honors. My name is Brian Isaac, and as you know, I represent the plaintiff appellant in this matter. I guess I should start my argument by stating that so soon after Sanitas, you would think that you had resolved the issue of who is or who is not an owner and who is a responsible contractor, but it seems as if the cases keep coming up which require further elucidation.
What about Scaparo, which we decided after Sanitas?
That is a case that my adversary did cite, and in that case the difference was that the Industrial Development Agency had absolutely no connection with the work at all. It was a right-of-way. The appellate division found that they had no connection with the work, no nexus. Here there is.
Well, they had no benefit either, right?
But this Court has held, even before we get to Abadiello or we get to Sanitas,
right,
there's no question that this Court has held consistently pre-Abadiello. And I'm talking about Celestine, I'm talking about Gordon, and I'm specifically talking about Coleman, which I'm going to discuss a fair amount in this argument to the extent I have the time. This Court has held that the fact of ownership with respect to 240 and 241 of the labor law establishes liability. The owner doesn't have to know about what's going on, doesn't have to benefit, and certainly doesn't have to consent.
Well, we have said there has to be some nexus.
Correct. And that's the Abadiello decision.
You know, what's the nexus here?
There are a bunch of, I'm not sure if the word is nexuses or nexi, but let me try to.
Nexii or something, right?
Let me tell you what they are. Probably the most important in the context of this case, and I know that my friend Mr. Palladino disagrees with me on this, but you have an interchange here where the interests of the state and the interests of my client's employer, New York Water, the water company, kind of intersect. It's almost a Coleman situation. The roadway in this case, based upon my review of the record, undisputed, was buckling. There was a...
I'm sorry, was what?
Buckling.
Buckling.
That's the word that was used, buckled. I don't think there's any dispute about that. And I think all of the New York Water employees essentially testified that the water was spouting out.
So why didn't they notify the regional DOT? I mean, because there is an important policy reason to have the state know when somebody's going to be doing work on the public highway, because there's public safety concerns. You might have to divert traffic. You want to be sure the work's done properly.
That's actually something that I wanted to discuss. I don't deny that New York Water should have gotten a permit. I mean, I think you can read all of the regulations because the initial paragraph on both 1220 and 52 say except for as not requiring a notice in an emergency situation, but none of the courts have agreed with that.
They had some kind of a permit here?
There are two types of permits based on Mr. Luchner's testimony that you can get. The first permit is in what they call an annual permit. An annual permit is, I believe, what the bigger water companies will get. It allows them to go out at any time in any situation and provide notice after the fact. And then you can get an emergency permit. The problem is that it takes at least 24 hours to get that permit. And if the water is spouting out, you have a situation.
Is this a common situation where you come in an emergency and you just say, gee, there's no time to get to give notice or to get a permit for this particular job? Is that an everyday occurrence, an every year occurrence? How often does that happen?
I would say that it's not an occurrence that takes place regularly, but as someone who actually lives and works in the city, it occurs a lot more than we would like it to and a lot more than we would want it to.
Can they go in there and contain the problem and then apply for a permit if they have to do more repairs?
What my adversary says in his brief is true. What they could have done is they could have shut off the water,
right,
which would, of course, be an inconvenience to the many people who need the water for that time, call an emergency 24-hour number, get a permit, and then do the work subsequently. But with respect to something that Judge Buffet...
But suppose they did nothing wrong. Suppose they were lawfully doing what they did, that the law entitled them to do it. How is that different from Abatiello?
Well, I think the difference in Abadiello is what you held in Abadiello, as I read it, is that the owner, even though was the owner of the fee, was essentially cut out of the equation. If you look at the syntax of the opinion and the structure of the opinion, which I looked at for a long time last night, it was interesting to me. The Court started with a discussion of 211 of the Public Services Law, which is the enabling statute, talking about the public policy of ensuring that we have cable television, at least in New York City, and then discussed the specific easement statute, which was 228. If you read 228 textually, you'll see that, at least in my reading of that statute, the public cable company can enter an owner's premise even if there is no tenant there. There was a tenant in that situation, but there's a public interest, there's a public service, there's no nexus just by having that building.
But you're saying that they had the right to fix the emergency because there was isn't that a public interest too?
Well, there's certainly a public interest, but here there's another public interest. The public interest is the road. This is a road that's buckling, doing nothing.
What would be the consequence if they didn't come in, if they hadn't come in?
Well, at the time, if they hadn't come in...
That would warrant the emergency.
It's simple. The water is spewing up all over the place. That's the testimony, and the road is buckling.
Who would have been responsible for whatever the result was of that water spewing up?
It's a mixed question, and I have to answer it in a mixed way. The water company, to my understanding of what their responsibility is as a water company, it's a quasi-public company, they'd be responsible for the main. The state, as a municipality, as the state, is always responsible under Lopes, Anino, Friedman, the rest of your decisions, for the condition of the roadway. The state did stipulate that they controlled the roadway and they're responsible for its maintenance. So it would be a dual function. I think that ultimately we would probably be responsible for what occurred because it was our main that broke, and at least from my reading of the record, Judge Littman, it seems that the water spewing up caused the breakage or the buckling of the roadway. So it was an emergency situation. The motivations on the part of New York Water were good. Mr. Kane's belief, right or wrong, was that in an emergency you didn't have to have an authorization to go in.
Their view was that they were doing a favor to the state?
Not at all. They were doing their job. Not a favor to the state. They were doing their job in what they were required to do by virtue of the
Even without
license.
being asked?
Well, they had to. I mean,
So what was the link? I've lost what the link is. I mean, clearly we tried to refine a rule in Avitiello, and then we applied it in Sanitist and Scarpero.
Right.
So
let me give
since, what is it, 2004, we've been looking for what the nexus, the link is. How would you legally define the link here?
Let me tell you why I think Sanitas and Coleman govern and why Abitiello
Well,
does
what's
not.
the link, though? I'm looking for the
link here
link.
is the roadway, the fact that the roadway was buckling, that it required some remediation immediately, whether it's turning off the water.
So the link is that the water mains are under the roadway.
That's the link here, absolutely.
And
No
it's
question about it.
It's your water main.
It's my water main.
It's not the state's water main.
It is not the state's
It's the
water
state's highway.
The state's highway,
Mr.
correct.
Shute, I appreciate, you're making this argument that you're trying to help the state out. State's big. There are a lot of towns, there are a lot of villages, there are a lot of smaller entities that could be faced with the same situation where some utility would go in and do something, let's say almost identical to this, and do it poorly. They would do a trenching job without proper shoring, and someone could be seriously hurt. And the town, village, or however small you want to make that municipality may be saying to itself, if they had gotten the permit they were supposed to get, we could have gotten the insurance that we needed, and we couldn't, and we didn't. And now we're faced with this substantial liability solely because we're the owner, because the Court of Appeals, in a case back in 2010, said it doesn't make any difference what the contractor does here, however poorly, we're going to be stuck. Now, how would we answer your question, so that we can protect the citizens of all these municipalities who otherwise might be exposed?
Well, I have an argument, but I don't think it's the one you think I'm going to make, but I'm going to make it anyway, because I hear this argument all the time, and quite frankly, I think members of the plaintiff's bar, every time we're asked this question, we blow it. Every single time. I'm going to try not to blow it. I may blow it by losing the case, but I'm going to try not to. Here's my argument. Liability under 240 and 241 of the labor law is designed to be unfair. It's designed to impose liability. It isn't fair when a construction worker goes to a site, puts up his own ladder, the ladder falls down, and the owner's liable. It isn't fair in that sense. But we draw distinctions in the law all the time with that regard. Judge Littman, if I can, I'll reduce my lifetime.
Finish your thought, your answer to Judge Pickett's
We
question.
have no problem with respect to special relationship or special duty cases pre-McLean, pre-DiNardo. Those cases were terrible cases where the municipality did terrible things, But for policy reasons, we don't impose liability. The same thing happens in the mammogram cases with women who go and they're told they have a perfect mammogram and they come back 3 years later and they've got stage 4 cancer, they've got 3 weeks to live. They can't sue because there's a policy reason. We have policy reasons. This Court has held since 1867 in Quigley against Thatcher that these laws are applied this way because these workers are, quote, scarcely in a position to protect themselves from injury. And there is a protection, and there was a protection here. There was insurance here, as you know. It's not activated, it wasn't triggered, but it wasn't triggered because Judge Size found, with respect to Exhibit A in my adversary's brief, that they didn't act fast enough. So you can protect yourself because unauthorized work, trespassing work, is never protected.
Okay, good. You'll have your rebuttal.
Mr. Palladino, how would a 2-day permit process have addressed this roadway emergency since there was water and buckling?
Well, as Mr. Isaac conceded, there was a simple remedy, shut the water off. That would certainly have inconvenienced some of their customers, but under the circumstances, they were required by law to do that. A permit is required.
Couldn't they also have had a permit in advance that would have protected them for this, in this situation?
Yes, if they had an annual permit, they would have had to have given telephone notice, not after the fact, as Mr. Isaac suggested, but beforehand. The permit serves two purposes. It makes sure that there's insurance and the state knows about the insurance and an indemnity agreement. And the notification gives DOT the opportunity to go to the site and inspect the site to make sure that the work is being done in a manner that's safe.
Do you disagree that, A, there's a nexus here, and B, that you benefited from their action?
I disagree with both points. There is no nexus. They were trespassing. They literally had neither privilege nor permission.
The water main being under the road is not a nexus. It's your road, isn't it?
It's our road. It's their pipes. We do not benefit. Their broken pipe
You don't
was
benefit
ruining our road.
by them fixing it so your road doesn't buckle or whatever happens?
They were fixing the pipe in order to restore service
You
to
get
the
no
customers.
benefit from what they did.
We get an incidental benefit just as when the cable technician went to the apartment building to fix the cable service, the owner of the building benefits because a building with cable service is more valuable than a building
Well,
without
it's a
it.
little different. This goes to the heart of what you own, right? Your road.
It's true that
That's not just an incidental benefit.
but when this court has used the term nexus.
Say you did benefit. Assume you did benefit. Is that enough? If there was a nexus and you benefited, is that enough
No, Your Honor, you seem to
in
be.
an emergency situation?
No, Your Honor, you seem to be equating benefit with the nexus. I mean, if work crew is dispatched to House A and they go to House B, start repairing House B, you can't hold owner of House B liable just because they happen to repair his house. They trespassed on his house.
But if there had been a permit, there would have been a nexus?
Well, yes, because in that case, they would literally have had the state's permission, and the state would have had notice. It would have had the opportunity to go to the site, inspect the work, make sure it was being done safely.
Mr. Palladino, it's unclear in the record, at least to me, unless I overlooked it, whether or not this water line that goes under the road was there pursuant to a right-of-way or an easement. Do you know which?
The record does not reflect, but it doesn't matter. Let's assume that the pipes were there. They were installed in 1928, by the way, pursuant to a permit from DOT. That would have been permission to put the pipes there. By virtue of the highway law, vehicle and traffic law, and DOT regulations, you must have a permit in order to maintain those pipes. If you do not have a permit, you are trespassing. You are violating the terms the legislature has put into place for digging up the state's roadway.
Didn't this water company have some permits in the past? Did I understand the record correctly?
In past years, they had annual permits which sort of expired. For whatever reason, they failed to renew them.
They also claimed that they did some work in the past without permits.
They claimed, yes, the officials from the water company believed mistakenly that a permit was not required in an emergency, and there was testimony that they, on a number of occasions, had performed work like this, all without the knowledge or consent of DOT. They're wrong. I mean, the regs could not be clearer. 126.6 which sets forth the instructions for obtaining a work permit, say these instructions apply to permits for emergency repairs.
Counsel, what does Sanitas control this situation?
Well, there the nexus was the lease. There, the tenant was given a property interest.
There even the tenant violated the lease, right?
True, but you could not.
And that didn't matter to the court, even though they violated the lease, which is, a pretty serious, thing to be dealing with. They violated the lease, and yet Sanitas said, nexus, okay, no problem.
Well, yes, but there a contrary ruling would allow the landlord to escape the liability provisions of the labor law by sticking provisions in the leases.
But the labor law is a strict liability situation, as your adversary was talking about, right?
We're not dealing with a private party trying to contract his way out of the obligations of the labor law. We have the legislature enacting a law that says if a utility wants to dig up a state roadway, it can do so only if it has a permit.
But part two of my question, Mr. Isaac, about small counties or small villages and things like that, is you had a claim over. I mean, the New York Water Service Company would have been a third-party defendant, and so you would not ultimately have been held liable under, you would have been able to pass it through to them, who you believe to be the responsible party for this. Isn't that the way 240 normally works?
Well, yes, and as Mr. Isaacs indicated, we didn't know about the insurance when the claim was filed. We eventually found out.
But that shouldn't make any difference.
It doesn't, because what we lost was the opportunity to go to the site and inspect the site when the work was being done.
But consider for a minute that you're dealing with a 240, a 241, where they're saying that there was a trench that caved in. It's not strict liability. You're right, it's not a 240, but it's close. And if you had brought New York Water in, you had been sitting there watching this thing, wondering how much he was going to collect. You would never be responsible.
Right, but if they had had the permit, we would not have been going through the time and expense of defending the lawsuit. We would have the insurance company hired by the water company. Now,
why were you an added insured? Why did that happen, that you became an added insured?
Well, I assume that they I don't know why they had the insurance, but I assume that they were aware of that requirement. What they did not comply with.
But that benefited you, right? It should have benefited you.
It would have if we had known about it. We under any case, we lost the opportunity to inspect the site. We would not have been in a position.
Think they do that of their own volition, that they make you an added insured?
Well,
should you have known about that?
I assume they did that because they were partially aware of their legal obligations. They apparently were unaware of their obligations with respect to permits. Now, he's arguing in his brief, I don't know if he's abandoned that argument here, that somehow they didn't need a permit because it's an emergency. I think that's refuted by the plain language of the regulations. But let's assume for the moment he's right. He still loses because in that instance, the water company's presence on the property is not due to any action by the state. It would be due to legal compulsion. If we couldn't keep them off of the property, the state, as owner, is in the same position as the owner of the apartment building in Abatello, who couldn't keep the cable technician from coming on the property. We would be in the same position as the property owning in Scaparo, where the village workers went onto the property pursuant to a right of way. That right of way wasn't granted by the owner, so it was legal compulsion. That was the
Let's say there was an explosion, an underground explosion. Nobody knew what the cause was, and yet it caused a lot of damage above ground. Windows were shattered, et cetera. Isn't it better to have a rule that would allow the waterworks and Con Edison and New York Telephone and whoever may have underground lines on the scene immediately without having to ask the Department of Transportation whether or not they can excavate under the street?
I would disagree with that as a policy matter. I mean, I think in this, if you had like a true, this really isn't an emergency because you could shut the water off. But I think what Your Honor is getting at is what if you have something like a ticking time bomb?
A water main break, or
the gas break, and they call us up and they say, "Oops, we don't have an annual permit. DOT says, well, you need an emergency one. How long will that take? 24 hours. We don't have 24 hours. DOT can either say, too bad, do not do the work, clear the area, or they could say, go ahead. In either case, DOT has notice, and it's giving consent if the company actually digs up.
Is notice and consent what's required or nexus?
In this
On the
permitting,
sanitars.
that would be a requirement. It's not, there could be other
What's the
bases.
answer to that? Yes or no? Is it notice and consent, or is it nexus?
Well, it's nexus, and in some circumstances, notice and consent can constitute nexus. If they somehow had an easement that somehow provided you can dig up the roadway notwithstanding the provisions of the highway law and DOT regulations, assuming that somehow was valid, that might have been a nexus.
The landlord in Sanitas didn't have notice and consent. Why was he liable?
In Sanitas, because of the conveyance of the leasehold to the tenant, that put the tenant in a position to bring someone onto the property, and likely without the knowledge of the landlord. You couldn't characterize the tenant or the work crew that he or she brought in as trespassers. There was a conveyance of an interest of property that gave literally the right to control or enjoy the property and bring workers onto it. Here, the highway law and the vehicle and traffic law have expressly said, thou shalt not dig up our roadway without a permit. We didn't convey, there's no proof that we conveyed some type of instrument that said you can dig up this roadway in an emergency. If we hadn't, it might be a different story. You'd have to get into the question of whether such an instrument could override the provisions of the highway law.
So even in my example, where you have this real emergency,
right,
somebody couldn't come and dig up your road without consent, without a permit?
If they take heroic action, and I would say perhaps that would constitute either factual or legal compulsion, which would relieve the state of liability. I mean, I think obviously what's going on here is you have this worker. He isn't responsible for the lack of a permit. He didn't know, probably had no idea whether a permit was required. But he does have a remedy. It's workers' comp. The problem is workers' comp is inadequate to compensate him fully. Perhaps the legislature should amend the workers' comp law to provide him with an additional remedy against the water company in these circumstances. If you hold the state liable here, the state is acting as an insurer.
And it doesn't matter at all if you benefit from that action. Let's assume you benefit from it, that your road is maintained or in better shape.
No.
That has no relevance if you don't get the permit.
I wouldn't describe it as irrelevant. It's just insufficient. I would refer you back to my example of work crew goes to the wrong house and benefits the owner of the house by repairing their house, and he comes out and says, I didn't authorize this.
And again, you would distinguish Sanitas because of the tenant's relationship to the landlord?
Right. There was the conveyance of the leasehold that gave the tenant the right to use and enjoy the property, gave the tenant the means to bring onto the property a work crew who could not be then characterized as a trespasser. That was the property interest.
Mr. Palladino, what does the permit say that is so significant in this case? I mean, are there certain strictures in there or requirements for the permit to be granted?
Well, the permit essentially has to provide that the utility has insurance, it has an indemnity agreement. As part of the permit process, the utility provides us with a description of the work to be performed.
Well, you got that 1-year permit.
Right.
That wouldn't apply then, would it? Because you don't know what the work's going to be.
In an emergency situation, though, we would give them a permit once they showed us that they had the insurance, and once they told us the nature of what they were doing so that we could go out.
No, but I'm talking about, isn't there a 1-year permit?
That's the annual permit,
All right,
yes.
so in the annual permit, they don't know what they're going to be doing for the year. It's just an annual permit that says you can do stuff, I guess.
Right, but under the regulations, they would call us up.
Oh, okay.
And they would say, we've got an annual permit, we've got an emergency going on, this is the nature of the emergency. That gives actual notice to DOT. DOT can dispatch a crew down to the site, see whether or not the work is being performed in a manner that is endangering the motorists.
If that permit had been in place and had been complied with, would you be liable here?
Yes, because they would literally have had permission to do the work.
What's the difference between an annual permit and an emergency permit, then? They both have to call you, I mean, why get an annual?
Well, there are different time requirements that have to be provided. I mean, it's much easier to have an annual than just make a phone call, and as opposed to if you don't have an annual, when you have a need to do a work, you've got to get a permit application in quickly.
Is there, I know your time's almost up, but is there any, in your experience in this particular case, is there anything in this case that showed that New York Water Service Company, in what it did, had they asked for the permit, would have been denied one? In other words, did they not have insurance? Did they not have an emergency? Were they not qualified to do the job? Anything like that?
The only, I guess, basis for denying them the permit in the emergency, I assume, would have been if they didn't have the insurance in the indemnity agreement, or if they were refusing somehow to tell us the nature of the work. It's clear that if they had done the right steps, they would have gotten the permit, but in that event, remember, we both would have known of the insurance. We wouldn't have been in a position to screw it up. And number two, we would have had an opportunity to go to the site to make sure that everything was done in a safe manner and to maintain the integrity of the road.
You might have told them you've got to shore that hole.
Yes. I mean, I will admit, the general purpose of the inspection isn't to supervise the work. It's to make sure that it's not interfering with the traffic or presenting a hazard. But obviously, if there was an obvious defect, if the DOT employee noticed that there was this 6-foot deep hole that wasn't shored, he might have said something.
Okay, Counsel. Thanks.
Thank you.
Counsel, what about how your adversary distinguishes Sanitas? He says it's the leasehold that makes it different, does it?
It isn't. That's just not what this Court said.
Why?
Because
Yeah.
this Court essentially used the nexus analysis in distinguishing Abitiello from Sanitas. And in fact, it can't be notice, because this Court has always held, with the possible exception of Abitiello, but as Abitiello is construed post-Sanitas, that notice is irrelevant.
Well, why isn't the leasehold the nexus?
Excuse me?
Why isn't the leasehold the
In
nexus?
Sanitas, the leasehold was the nexus. Here, the interrelationship between the way in which the water pipes are laid, the fact that the water is shooting up, the fact that the road is buckling provides that nexus.
Well, what's the difference between the water pipe here and the non-working cable in Abitiello?
In Abitiello, as I read the decision, again, it has to be read with Coleman. And I want to make this point. I don't think I made it appropriately in my first go-round. In Coleman, if you read the briefs in this Court and read the briefs in the appellate division, the City of New York made the exact argument my adversary is making. He said, look, by virtue of legislation, 1200 of the Public Authorities Law, we, the City of New York, are prohibited from going into the subways and having any relationship to this work. We used to run it. We don't anymore. And therefore, the legislation prevents us from doing that. That's his argument. It's a permit. It's legislation. If you rejected it in Coleman, you should reject it in here.
What do you say is the distinction between Coleman and Abitiello?
In Coleman, well, in Abitiello, I think what the Court said is that the owner was just cut out of the equation completely. There was no nexus, no benefit, and in fact...
But there was a benefit. I mean, it's good to get your cable TV fixed.
Well, I don't think it really matters in the context of that case, especially if you're looking at the easement that 228 of the Public Services Law provides. The building is the building. Whether people have cable television or not is not going to really impact, at least in New York City, on whether somebody goes there or not. So I think that is essentially the difference that we're talking about here. If you're going to use a legislative analysis like Mr. Palladino...
Well, I can understand that a cable TV is kind of a luxury and a road that's not buckled is sort of a necessity, but is that really a valid distinction?
Well, if you're going to use a nexus test, it absolutely is. Look, I'm not saying I'm here unless the road, unless the water main is under the road. That's why I'm here.
If we agree with you, Mr. Isaac, then why does any water company around the state need to bother to notify or get a permit from DOT?
Well, we're talking about two
for
different
emergencies.
things.
They can just always go in and presume if something goes wrong, the state's also liable. I mean, there's a public interest in trying to assure that the people working adjacent or under the roadway have appropriate insurance coverage.
I never claimed that there wasn't. There was coverage here.
But that may not always be the case in the future.
That may not be, and if that's what happens, then there's an easy remedy, because the state is competent, and what they can do is they can just go on their files. They have, as you know from reading Mr. Letchner's testimony, they have a kind of card catalog file system, and just ensure that every single water company goes and has those permits in place. It's a very, very simple thing. If they don't do it, they can get it for them, or they can withdraw their license.
There's another issue, though, and it hasn't been mentioned here, but you're the one that's now going to fix the road, not you, but the New York Water Service Company. And if they decide that they're going to send Curly, Larry, and Moe Construction, Inc. out there to fix this road, they could be making a greater problem for the state than the state had if you hadn't done the fix. You can do it on, someone can do it on the cheap, some can do it ineffectively, someone can do it unsafely. Now you have an unsafe road that could cause more trouble than the water main underneath. So they do think they need a permit, they need notice, and they need an ability to inspect and make sure that the proper construction is done. Doesn't that carry some weight in the thing?
Look, this is the Court of Appeals. We're not here on a rear-end accident case. I didn't say that the state's position was frivolous. It isn't. There are some weighty issues here, and he has some issues on his side, just like I have some issues on my side. I just don't think it's sufficient to overcome the labor law. Can I have 30
Does it matter that you're not a fly-by-night operation, that you are who you are?
I don't.
New York Water, or does it not matter? It could be any Tom, Dick, or Harry who comes in there to fix it.
I don't think there's such an animal, if I can, as fly-by-night water companies. I know Mr. Palladino didn't like my citation to Rochester Lake in Ontario against the city of Rochester at 176 New York 36, but I think you might profitably consult that case, because I think that there are special licenses that need to be secured in order to actually get the certificate of incorporation with water companies. We don't give them to Tom, Dick, and Harry. It's just not the way the system works. One other thing, and this is something that may be...
One thought. Go ahead.
That's it. I'm done. Judge Piggott, you asked a question, and I think my brief might have been inadequate. It's probably against my interest, but I want to say it anyway, just so nobody's misled. You spoke about the shifting of liability in a 240 case. It's absolutely correct under common law. I didn't discuss it. Mr. Palladino discussed it. Perhaps we should have. There is one problem with that, even from my perspective. Workers' Compensation Law 11 only allows the shifting in cases of a grave injury.
Grave injury,
so
right.
to the extent you're making that determination, I don't want you to say I didn't say it. That presents a problem.
Thank you both.
Thank you, Brian.